Our first speaker today is Robert Popper. Bob is a graduate of the University of Pennsylvania and Northwestern University School of Law. In 2013, Bob joined Judicial Watch as a senior attorney and director of Judicial Watch's Election Integrity Project. Before that, Bob worked in the Civil Rights Division of the Department of Justice for 8 years, 5 as deputy chief of the voting section. Before that, he worked as a private attorney in New York for 17 years with a practice that covered a wide array of legal issues, including voting rights. Among Bob's many notable professional accomplishments, he developed a legal standard relating to gerrymandering that is widely cited by experts and was adopted by the Arizona Independent Redistricting Commission.
Good morning. My name is Robert Popper. I work at Judicial Watch, and prior to that I worked for 8 years at the Department of Justice, in the voting section of the Civil Rights Division. And I'd like to talk today about one particular item. I interpreted my charge as advice I would give to the administration. And the statute I would prefer that the administration enforce is called the National Voter Registration Act. I'd like to talk today about how this statute has not only not been enforced by the prior administration, but about how it was actively damaged by that administration. My simple advice for the Trump administration would be to start enforcing that statute, or at least to stop attacking it. Section 8 of the NVRA is the provision in federal law that concerns list maintenance. And list maintenance is simply removing voters who have moved out of state or who have died. And voter rolls are constantly becoming clogged with invalid registrations. Federal law requires that they do something about it. States hate to do this. It costs money, it takes time and effort, and they often need prompting in the form of lawsuits. Now, our own research at Judicial Watch indicates that out of about 3,000 counties in the United States, 300 have more registered voters than citizens of voting age. That can happen for a variety of reasons. The registration rates can increase, but typically that indicates a problem. And every year, I would add, there's a couple of counties that have more registered voters than total population, including non-citizens and infant children. What the voting section has been doing about this is worse than nothing. To begin with, they're doing nothing. Or they've done nothing. In 2009, the Deputy Assistant Attorney General over voting informed a meeting of voting section staff that the management of the voting section did not care, her words, about Section 8 of the NVRA. This became a locally famous meeting, famous in a Washington way, meaning the Inspector General investigated this remark because enforcement agents should not be deciding which statutes they do or don't like. Regardless of this investigation, the administration under Obama was true to its word. No cases were brought in the past 8 years. No cases have been brought since I brought the last one on behalf of the federal government in 2007. During the Bush administration, there were 5 such lawsuits. There are none now. These suits are now being brought on behalf of private plaintiffs by Judicial Watch and also by the American Civil Rights Union. But that's it. They're expensive cases. They should be pursued by the voting section. Worse than doing nothing, the voting section is litigating to pare back the NVRA. And if you think about it, this is remarkable. A federal agency making war on one of the statutes it is charged to enforce. I can give you 2 examples of this, very recent examples. The first concerns Florida, where there was a lawsuit in which private plaintiffs and the United States argued that the 90-day freeze period of the NVRA applies to non-citizens. Now, the freeze period is a very logical 90-day period. It's very logical in the statute. In that period, you cannot remove individuals who are suspected of having moved to other states. It's just too near to the election. You can do that the rest of the year, the rest of the election cycle. Well, the argument was that this applied to non-citizens as well. Now, they were never eligible to vote if they're non-citizens. Both district courts rejected this, but a 2-to-1 panel of the 11th Circuit accepted it, and Governor Scott declined to pursue the appeal. So it is now the law in the 11th Circuit that in the 90 days prior to an election, non-citizens cannot be removed from the voter rolls. You should ask yourselves, as I have asked myself, why does one pursue that remedy? All I can come up with is that whoever pursues that remedy does not want non-citizens removed from the voter rolls in the 90 days prior to an election, because that's what the ruling was. Again, attacking and paring back the NVRA's protections. The second example I can give is a couple of cases out of Ohio and Georgia, in which the United States joined with plaintiffs, with amicus support, in arguing that states can't use the fact that someone has no voter activity for 2 years in Ohio and 3 years in Georgia, can't use that fact as a basis for sending someone a notice inquiring as to whether they still reside in the state. That would contradict or contravene the NVRA's restriction on removing people simply for failing to vote. 2 district courts rejected this, but 2-to-1, the Sixth Circuit Court of Appeals reversed. Both cases are on appeal. But again, this is an instance where the Department of Justice's voting section is attacking a statute it doesn't like, using what I would consider forward partisan arguments to pare it back. If the Trump administration does not enforce the NVRA, it should stop attacking it. I have faith it will do both. The last point I would make, and I'm fear I'm over time, but the last point I would make is simply this. There is a separate debate about voter ID laws, state voter ID laws, and I'm a big fan of state voter ID laws. I think they're constitutional, they're commonsensical. But just know that if we stray into that territory, that's a different topic. The NVRA is a federally enacted statute. Congress already weighed the pros and cons and decided it was going to enact this bill. The Department of Justice should not be in the business of picking statutes it likes and enforcing those, and then taking statutes it doesn't like and attacking them. That would be my point to you today. Thank you.
Thanks, Bob.